Good morning to everyone. This is Virginia Poverty Law Center's coffee chat on the gray market in mobile home parks. And I'm very pleased to have everyone here this morning. This was kind of a back by popular demand topic. In November, Joe and Phil presented on mobile home park issues and building community. And many of you who were at that particular coffee chat kind of requested that we do another one once the General Assembly began to kind of get a idea of how things could potentially go for a mobile home park legislation or not go, right? So we're about 2-3 weeks into the General Assembly, and Joe and Phil were kind enough to be with us this morning to update everyone. But before we begin this update, quick announcement that we will end at 9:30. If for some reason this conversation is still going on, feel free to stay. But at the same time, no need to announce that you're leaving at 9:30 because you may have other things to do. The entire coffee chat will be, as you know, recorded and hosted on VPLC's YouTube channel. And Ezra Halstead, who is VPLC's event and outreach coordinator for more than just housing, is here if you experience any tech issues, and the email will be coming from Ezra with the follow-up of resources and the link to the video. So that's enough from me. And I should have introduced myself, which is Tony Maxey, VPLC's Director of Development. But I'm going to turn it over to Phil now and go off screen so that you guys can concentrate on Phil and Joe this morning. But Phil is VPLC's housing attorney and director of the eviction legal helpline. Take it away, Phil.
All right, thank you, Tony. So we just wanted to start by saying that the information that we're sharing here is stuff that that we have seen and that we find out about because there are people who have need for legal assistance, and so they reach out to us. There are very good, very well managed and well run manufactured housing communities in Virginia and all over the place. So my parents lived in a park in a manufactured home the last, 20 years of their lives, and it was wonderful. I wish I could move there and live there. It was in California. But so there are great places where some of these problems don't happen. There are an awful lot of smaller, older manufactured home communities in Virginia where there are a lot of problems, and the residents do need extra assistance. And so that's what we're gonna focus on, because that's the stuff that we're responding to. But this is not to paint the entire sort of sector with the same sort of problems as we're going to address today. So just want to get that out of the way. We'll also, I'm going to introduce Joe, because Joe is going to start telling us about what some of those problems are. Joe Ciszek is a housing law attorney here at VPLC, works on the eviction legal helpline and on manufactured home park issues, and has been working in manufactured home parks for, 7 years, something like that, for quite a while. So, and we've worked together a lot over the years. And he's a great resource for folks who have questions about what issues are. That's one of our roles at VPLC for the larger legal aid community and the broader community in the state, is if we have questions about certain issues, we try to help be a resource. So Joe is a great resource for this kind of stuff, and I will turn it over to Joe to explain what we mean by the gray market in manufactured home communities.
Thanks, Phil. So the gray market is a term that we're using to describe the current system through which folks live and operate in the manufactured home communities across Virginia. When there is an absence of a functional, legitimate market for buying and selling your mobile home and enforcing the legal rights that you have living day to day in a mobile home park, there arises a gray market like this, which operates outside of the sight of the law. When I first started doing this work, I was shocked at, not only that a lot of the protections were weak or hard to enforce, but that, a lot of them weren't even being enforced at all, because a lot of this stuff just happens in the dark. This affects particularly lower income areas and folks who have other increased vulnerabilities, such as recent immigrants who may not have a predisposition to use the systems that exist, regardless of the fact of those systems' inadequacies. So it can really create a strong additional burden on folks who need the most support. When manufactured homes are bought and sold outside of the view of the law, the only thing that really controls are the power dynamics, and those supplant folks' legal rights. And that is very concerning when we are operating in a system where folks own their home but rent the land beneath it. It can be quite precarious, but we want to encourage folks to have the peace of mind to invest soundly in their home and make it a good place to live. That's what we all want for ourselves and our neighbors. This gray market can cause some serious issues for tenants who live in these communities, tenant homeowners, to be quite clear. So Phil, if you wouldn't mind describing some of what that looks like.
Yeah, so I'll tell you some stories, and these are stories about clients that we've had and situations that we've seen personally that are sort of examples of things that go on in various, unfortunately, poorly managed and poorly sort of scrutinized mobile home parks. But for instance, there was one owner, thankfully, I don't know if he's gotten out of the mobile home park business completely, but at least partly. What we saw with him was he would enter into rent-to-own contracts to sell an older mobile home from, say, the 70s or maybe early 80s, to usually an immigrant family, very unequal terms, or I would say unfair terms to this contract, some illegal terms and things like that. And then when the person had paid off the home after 5 or 6 years or something like that, he would give them a piece of paper, called it a bill of sale, and said, hey, this document would say, I don't have the title for this. You're welcome to go to DMV and get a title. Well, it didn't have enough information for them to actually get a title. So for years, they would have to try and get him, ask him to give them a title. He would say he doesn't have the title. He would say, go back to DMV. And you can imagine that somebody gets fed up. They have another kind of change in their life. They have to move out. He could do this over and over again with the same homes. My sense is that some of the homes he probably didn't have title for. Other homes, we were able to get involved, represent the tenant, and he managed to cough up the title after he was threatened with a lawsuit. So that's one of the things where, and it is not uncommon, unfortunately, for homes to be transferred without titles, older homes in older mobile home parks that are not well managed, for homes to be transferred without title, whether that's among private parties, third parties, or by the owner of the mobile home park. You can imagine if you are able to sell something over and over again without transferring title, the reasons for you to keep that tenant happy are a lot less than if you're going to have to go through the actual legal process to get title and things like that. So that's one of the things.
Some other issues that we see a lot are, problematic or illegal lease terms for the lot lease. So, Phil just described how, some of the contracts for sale can be, very predatory. The lot leases oftentimes have unenforceable provisions that are very damaging to the tenants. So I've seen a number of different issues related to that. One that is incredibly common is, issues with the duration of the lease or the renewal of the lease. Virginia law is very clear for mobile home lot leases that they are to be for the extent of 1 year. The landlord must offer all current and prospective tenants a 1 year lot lease. And the law states that at the end of the lease term that it renews for an additional year. This is to provide security for folks who own their homes, just a bit of predictability. However, it's not uncommon to see landlords only offering month-to-month leases, or a year-long lease, but it goes month-to-month after the current year. It's just plainly not in accordance with the law, but it just happens very frequently because there's little scrutiny, and enforceability of these provisions is suspected. There's very weak penalty protections for when these sorts of issues arise. Some other problems with lease terms are unreasonable park rules with large penalties. There needs to be a legitimate reason for park rules for them to be able to be enforced, but an unenforceable rule may not be obviously so to a tenant. I have seen, I can think of a specific case where there was a tenant who had a lease which said that, the front porch on their home needed to be clear of clutter at all times. They had a couple potted plants on the front porch. The landlord came and told them that if they, didn't remove all those potted plants within a short period of time, that they would issue them a $100 fine. They did remove the potted plants. They swept up the porch, but they had left the broom on the front porch after sweeping off. They got that fine against them for leaving the broom on the porch because it was still cluttered, you see. And it's just unfortunate that these sorts of things are going on right now. That sort of fine is a money-making scheme under the guise of, some sort of liquidated damage, which is just, it's not allowable under the law. But again, enforcing the law under the current state is very difficult to do, and often unreasonable for these tenants. Finally, a very common lease term that I see almost all the time when I'm reviewing these lot leases is a complete prohibition on subletting a mobile home. The Manufactured Home Lot Rental Act says that any restriction on a tenant's ability to lease or sell their home must be reasonable. The landlord, is certainly to be consulted, and if the homeowner is going to lease the lot or is going to lease the home to, a subtenant, they have to get the permission of the landlord, but the landlord cannot unreasonably withhold that permission. Well, the landlord is doing so if they say all subleases are necessarily illegal, not allowed under the lease. And so, these sorts of issues are fairly rampant, and I think, partly it's due to a lack of scrutiny, but it certainly arises out of our current legal system, which does not prioritize remedying these issues.
Yeah. So, and we see. So, one of the things, as Joe said, these illegal or unreasonable fees and things like that, the penalty provisions in these leases. One of the things, just to kind of emphasize the power dynamics, and why a tenant is unlikely, even if they know that a certain lease provision might be unreasonable or illegal, why tenants are maybe sometimes unlikely to try and defend those rights. So there's one mobile home park, thankfully it was sold a few years ago, but the previous owner that had it, he had a neat little thing that he would do where people didn't have written leases. He didn't want written leases. They would just give him their rent. And then he would, and I don't know how he picked who he would do this with, but he would knock on someone's door and say, look, I ran the numbers on your account, and you actually owe me like $4,000. Some of those back charges could be from the previous renter that lived there. But he said, unless you pay this, I'm gonna have your mobile home yanked off this lot next Friday. And of course, there was nothing behind that, but people are in a vulnerable position. They don't know that, and so they would pay him, say, $2,000 or $2,500 to get him to back off. That's something that he did repeatedly in this one park. Once we had a relationship, I was working at Legal Aid Justice Center at the time, this was several years ago, but once we had a relationship with the community there, a couple people called us about this when the landlord was trying this. And so I sent him a nice, very lawyerly letter. My clients want to be responsible tenants, and so please just send us the lease and the ledger and explaining where these charges come from so I can explain them to the client. And that was the end of it. He backed off those things. But that's kind of the power dynamic. That's how vulnerable people might feel, that they might just cough up a few $1,000s if you threaten them hard enough. So one of the things that we see is, so when people don't know their rights or have less information about what their rights are, what the situation is, they're very vulnerable. So there was one mobile home park in Richmond that several years ago, the city of Richmond went in and did really aggressive code enforcement, threatened to condemn the park itself and threatened to condemn most of the mobile homes in the park. Well, there was one of the tenants had a home that had very serious issues, would have costed tens of thousands of dollars probably to repair these issues. And these are very old mobile homes, mostly from the early 70s, some from as early as the 50s, but this guy's was probably from the 70s. So he's looking at losing his home, having his home condemned. Well, there was the community that lived in this mobile home park. Many of them came from this one region in Mexico. And many of them spoke some Spanish. A lot of them spoke pretty good Spanish, but some of them didn't. They spoke Mixteco, and so they didn't have a lot of access to good information. Well, this homeowner whose home was under threat of condemnation ended up finding somebody else, an even newer immigrant from this region, to sell his home to. Sold it for like $6,000, pending condemnation in a park that could easily be condemned. Obviously didn't communicate any of that to the purchaser. So that's just, it's not all, when there's a sort of a gray market, when there's a sort of an anything goes kind of Wild West situation, it's not always the landlord that is taking advantage of that. Sometimes it's other people taking advantage of the disparity in information there.
And then so we're going to go to questions in just a second here, but just a little bit about what we are doing about this. The Virginia Poverty Law Center supports the legal aids across the state and works with them to remedy these issues under the current legal system. But we also advocate for improvements to the law and improvements to the legal system to try and deal with these from the ground up. We have been working to organize a tenant association so that tenants can talk amongst each other and acknowledge when these issues are going on so that they don't feel alone in dealing with them, and so that information about the illegality or unenforceability of some of these actions can spread organically throughout the community. We also are supportive of actions which would encourage resident ownership of the community or resident-supported nonprofit ownership of a community, as evidence across the country where these sorts of communities exist have shown that they just make better stewards as far as protecting the interests of the community, keeping lot rent reasonable, and ensuring that these parks don't close at all, which is what we discussed a little bit in our last session. This General Assembly session, there are a few bills going forward related to this matter. We have been working to try and overhaul the Manufactured Home Lot Rental Act. However, our partners and our our collaborators, it hasn't been. It's not a good time this particular session, but we already have plans to meet in the interim period before next session to try and hammer out an overhaul to this system in a more comprehensive manner. Frankly, the Manufactured Home Lot Rental Act, while it does have some unique benefits over general landlord-tenant law, still treats homeowners quite akin to someone who has the ability to just pack up and leave if things aren't to their liking. Furthermore, as I mentioned a couple times, the current penalty provisions in the Manufactured Home Lot Rental Act only apply to very particular types of violations, meaning that certain rights have no strong enforcement mechanism at all. Even if a tenant was to sue and have a court declare one of these actions illegal, they are limited to actual out-of-pocket losses and 1 month's lot rent, which is generally maybe $400, $500, which is just not a sufficient method of discouraging these bad practices. Again, these practices are not in every mobile home park across the state, and certainly there are good owners who try not to take advantage of their tenants, but the law should not rely upon the goodwill of the actors. It should set a baseline that is fair for all, and that is what we are advocating for. Now I think we can turn to some of the questions that have come in.
Sure. Thank you guys so much. Andrew Harding asked how receptive the DMV is to lost title or other legal action.
I can field that if that's all right. So we have reached out to the DMV previously to try and streamline this process. Unfortunately, that did not, it was not fruitful at that point in time. I hope that we can, come up with a better system. But as it stands now, there is a process to regain title, but it is indexed to some unrealistic criteria that tenants have to create or that tenants have to fulfill.
And I think the sort of big picture in the statutes, so that we'd really have to change statutes, I think, because the statutes say treat manufactured homes the same as just cars. And so now a 50-year-old manufactured home that hasn't been moved in 45 years is much less of a risk for somebody to say, steal it, take it to Southwest Virginia, put a new coat of paint on it and try to sell it, right? And so there really to address that, there should be probably some statutory changes. That's a big nut to crack, and we just haven't started looking at that yet.
Thanks. Sarah Foot, and I hope I'm not mispronouncing your last name, Sarah, but how likely is it that Virginia mobile home communities are heading toward enacting right of first refusal? This would offer protection for tenants if the park owner decided to sell the community, whether or not after mistreating tenants. So how likely is it that we're going to head towards that right of first refusal?
So that's something that Joe's been working on. I've been hearing, just for the sake of, my understanding is limited on this, but the good thing is that if it's right, that's at least brief, but there are huge political challenges to that, probably legal challenges to address how to make that work in a way that is that protects, people's property rights too. But Joe has been looking at more than me.
Yeah, it's an excellent solution for what we're trying to do. However, it's not an easy one because it requires the legislature to remove one of the types of ownership rights that folks have, which is to choose what they do with their property when they sell it. Generally speaking, as long as you're not discriminatorily choosing who you sell to, that it's your prerogative. To make it not your prerogative who to sell to is hard for a lot of folks to stomach. We are going to continue to push for that or something like that. We have looked at alternatives such as offering tax credits when selling to nonprofits or resident groups, and that looks promising. We're hoping to get that in a budget amendment this year potentially, just so that all else being equal, it will be advantageous to sell to a group that is likely to keep it open as a mobile home park. But there are some political and legal issues surrounding that, certainly.
And speaking of political and issues, as well as the fact that this is in the budget, I'll just mention that if you've not yet signed up for VPLC's e-newsletter, you can do so on our homepage of the website, just vplc.org, scroll all the way to the bottom and hit sign up or join our newsletter, whatever that language is. We do send out priorities for the week for the General Assembly session, as well as action alerts. And that can keep you informed on not just the mobile home park issues, but everything that VPLC is working on during the General Assembly. And Bill and Joe, I'm just going to ask you guys to look at Alexander's comment. And then you guys can follow up if needed afterwards.
We can follow up with Alex offline. He's got a case where he's facing this issue of the lease rolling into a month-to-month lease rather than renewing as an annual lease, and so we can. It's not uncommon at all, and we can check in with him after this. One of the things that I notice here is Susanna is asking, so what's the current requirement of adequate notification to manufactured home owners if their park is going to be sold? Right now, depending on, and Joe can correct me if I'm wrong, but depending on whether it was an unsolicited bid or whether it was listing the home, the park for sale, it's 90 days or 60 days notice that that residents are required to be given. So yeah, and if it is related to that, it's not being sold, but if the park is going to be converted to a different use and not be a mobile home park anymore, that's 180 days notice.
It's very close to 9:30. There are two really great questions, or if not more, in the chat, so I want to make sure that we get to those. But at the same time, as I mentioned at the beginning, if you need to leave at 9:30, feel free to do so. Julie Bolthouse has a great question. Not that the others have not been great, but do you know of any examples where municipalities or a nonprofit has purchased a mobile home park and continue to run them as a mobile home park? She's often heard that it's not ideal to maintain them as parks because it's a depreciating asset.
Yeah, so two parts to that question. So examples, yes, there's an excellent example just south of us here. I'm going to name drop Project Homes. They're a nonprofit that works in the area of affordable housing. They do affordable housing construction and rehabilitation and a number of different projects. They stepped in a couple of years ago to purchase a mobile home park that was under threat, and have since then really turned that park around in a substantial way. The park had significant deferred maintenance that they have been undergoing, and they have a resident engagement team that is allowing the residents to choose what investments come when. They've already repaved roads, they're putting in new lighting. There's a community house that is just a stick-built building in the park that they are having meetings about what the residents want it to be used for. It's a very encouraging model that we've seen starting to take foothold in Virginia. Another organization, Catholics for Housing, purchased a mobile home park, I believe in Manassas, and kept that one from going under. And that was a collaboration with the municipal government there when there were, significant deferred maintenance. And they were able to stabilize that community, work with the residents, and keep it open. But the second part of your question about depreciating assets, that phrase is tossed around a lot in relation to manufactured homes. What it usually refers to specifically is not the mobile home park as a whole, but the mobile homes within it. Common wisdom is that a mobile home is a depreciating asset similar to a car and is necessarily worth less as time goes on. While that may be true in a lot of cases, in other states that have resident-owned communities or a guarantee of some sort of long-term lease, either protections against lease non-renewal or long-term land leases, these assets absolutely can increase in value. A properly maintained manufactured home, especially one that's been built in recent years, is of the same caliber as a stick-built house, and can actually be a lot more affordable due to the nature of them being constructed in a facility where they can use economics of scale. So I think that the model as a whole shows significant progress to deal with our current affordable housing crisis. It's not a silver bullet, but it's part of the spectrum that must be encouraged, and it can be an asset that grows in value so long as it is stably tied to the land.
Yeah, and I think in terms of mobile home parks being a depreciating value and not being worth maintenance, boy, if you bought a mobile home park 5 years ago and you were going to sell it today, you would be making a mint. A lot of big investors are buying them so that they can run them as mobile home parks. So they're not a depreciating asset. A lot of people have been, I guess investors say, locking up gains recently by selling mobile home parks to big investors.
Yeah, and that's a big part of what motivates our work right now is that, this is an area where there have been ongoing issues, certainly, but we're at the cusp of a new battle, which is, a lot of investor purchases of parks for rehabilitation, or sorry, not rehabilitation, but redevelopment potentially, and closing them, or these investors who are going to raise lot rents indiscriminately and make it significantly less affordable for folks who live there. And while we certainly don't deny a landowner a fair price for the use of their land, it is troubling when the person who owns a home has no control over the extreme amount that the price could raise for their lot rent, or a simple non-renewal without cause, are both issues that I think we need to address immediately, because these are hot commodities these days.
Thank you, Joe and Phil. Sophia has asked in that she works to support residents of mobile home parks, where for one reason or another, many of these residents do not have a lease and title in their names, though they own the trailer and have been residing there long term. So what advice may you have to protect the legal rights of mobile home tenants in that situation in which the lease and title is not in their name?
I would contact your local legal aid. So there are a lot of really good advocates. Alex, who had a question here, a lot of others who, some of them are on this and others aren't, but there's a lot of really good advocates at legal aids around the state who are very interested in helping tenants protect themselves in these situations. So that's, I would say, be the first thing to do that I'd recommend.
And we can follow up with a link to how to best contact your local legal aid in the email that comes out from Ezra. So stay tuned for that, which will also have the recording of this chat. Miriam, and welcome, Miriam. I understand this is your first time joining one of our chats, so welcome. Miriam asked, are there any programs for repair or updating of mobile homes? Because every program that she's checked into, it seems like you have to live in rural Virginia. Are we aware of any?
I know that Project Homes does do some weatherization of manufactured homes, but I haven't heard of enough of these types of programs. So, you know, if you have a specific need for that, you know, certainly reach out to me. We're going to put our emails in the chat. Actually, I'll go ahead and do that now. Anyone who has questions or just wants to talk about these sorts of things are certainly welcome to reach out to myself or Phil. But yeah, no, that is a real concern. I know Chesterfield County has been pretty good about putting money into manufactured home repair and improvement. And you know, we're hoping to have better resources across the state, but you know, that also goes with the stigma that a lot of areas have against mobile home parks, where, you know, traditional wisdom in some land use planning circles is that, you know, mobile home parks are necessarily blight. In fact, some Virginia counties' comprehensive plans defined them as such until not too long ago. So, you know, there's changing opinions about this type of asset. I just recently read a USA Today article talking about how, you know, these parks are growing in popularity significantly across the country. So I think there's going to be more interest in this soon. We're on the cusp of something here. But yeah, unfortunately, there's not enough programs for, you know, helping out these tenants or, you know, homeowner tenants to, you know, get their homes how they ought to be.
Joe and Phil, thank you so much. I believe I've hit everyone's questions that were in the chat. If I've missed anything, feel free to unmute yourself and ask. So with that being said, I just want to once again thank each of you for coming to this chat. And again, I encourage you to sign up for our e-newsletter so that you can continue to be informed of the work that we're doing, help take action on any alerts that may happen throughout the General Assembly session. If you're unaware of what it is that VPLC is working on, we can put in our legislative agenda in the follow-up email, or at least a link to it. Thank you so much. And once again, Phil, Joe, thank you for your time this morning, and everybody have a great day.
Yeah, thanks everybody for joining.
Yeah, thanks. It was great to have you guys here.
Take care.
Bye.